I'm Jane Bailey. I'm delighted to share this panel after lunch today. It's about experimenting with AI technologies to enhance judicial actors' autonomy. We'll have 4 speakers. I'll say something brief about each of them, and I commend their bios to you on the website. Dr. Leah Wing is with us. She is the director of the National Center for Technology and Dispute Resolution and a senior lecturer in the Department of Legal Studies program at the University of Massachusetts in Amherst. Dominique Boullier, who is an emeritus university professor from the 19th section of the CNU in sociology. Hannes Westermann, who is an assistant professor of law and artificial intelligence at Maastricht University and the Maastricht Law and Tech Lab. And Erik Bormann, who is the director of the Guided Pathways at the Community Legal Education Ontario, where he leads the development of interactive legal tools, helping people to navigate legal processes. So each person's going to speak for around 15 minutes, and then we'll have time for a little moderated discussion and questions. And our first speaker is going to be Leah, so come on up.
So I'm going to take just a brief few minutes to talk about AI and how they fit into online dispute resolution standards, and the way in which we're thinking about online is really perhaps an old word from when the internet went public and the first experimentations with using mediation and negotiation and eventually ombudsing early on, when people started to fight online using email. And the terminology stayed the same, but basically it's referring to any time technology is utilized in handling disputes inside or outside of court. So, central to the discussion about ethics, one could say, is that AI magnifies opportunities and risks for access to justice, which many of our colleagues have already discussed in this morning's panel and rigorously at lunchtime as well, I've overheard. And this increased the urgency for including AI in dispute resolution standards. Online dispute resolution standards that include AI really should be guardrails, I would argue, not just for how do we prevent risks, how do we reduce risks, but also how do we provide standards which are really the floor. They're not guidelines, they're not best practices, but they're the basement of what's acceptable in order to harness AI for public good. Clearly, AI enhances efficiency, enhances reduction of cost, gives us many more brand new and ever-changing communication channels. It reduces the need for human intervention, and I'm going to put that on more than one slide, but it certainly can be seen as belonging on the slide about enhancing access to justice. And harnessing not just text, but also visuals to help us look at creative solutions, identifying problems, and also not just looking at what the future could be when we're trying to productively resolve a dispute, but also for early detection of where a dispute could arise or where liabilities could arise. So the positive impact, if I could summarize and overgeneralize, I'd say, is that it illustrates the productive, positive role that the disruption of technology makes in society and in the law and in dispute handling. And therefore, our governance mechanisms need to highlight that and lead us towards fostering AI for the public good, as I've mentioned. So the negative impact, clearly, as we've talked about already, hallucinations, but also the compounding and the embedding of these hallucinations and of inequalities and of bias. And I also want to just mention that I feel like so often, in general, the public and many of us in the legal and dispute resolution realms talk in wide generalities about risks, when actually those risks are not equal. And so if we think about a particular AI tool that could increase opportunities, they may not equally be increasing opportunities for all populations. The same thing when we think about an AI tool that could cause risks, and they may not be equal risks. And when we develop governance mechanisms that thinks about the population as a whole, as opposed to the population at the bottom, this has implications. So AI bias and hallucination infiltration, I want to cite some research from the Reg Lab and Institute for Human-Centered AI findings out of Stanford from last year. And they found 69 to 88% of the time in response to specific legal queries that there was hallucination. Oh, Lordy. So, why wouldn't the average mediator need to be worried about this? The average arbitrator, and clearly the average lawyer and judge. Dispute resolution standards for decades now have remained virtually silent on technology in general, and certainly silent on AI. That's changing, and that's important, but they have been relatively silent. Not addressing issues around data transparency, accessibility, machine learning, etc. So this is something that we have done a lot of thinking about with our colleagues at the UN, the EU, in other nations, and in other regional governance bodies in order to think specifically about creating guardrails. And we came up with several principles, I'd say, are goals to protect against unequal procedural and substantive justice, and also being concerned that inadvertently, and perhaps for some purposefully, but we could say for many, inadvertently, software developers and LLM architects are becoming the gatekeepers for access to justice. Market forces and good intentions have clearly been insufficient. And as I said before, it's getting compounded. The risks are getting compounded as things change rapidly and our guardrails are either missing or insufficient. So it's necessary for ethical AI to be applied to dispute resolution that we need a set of standards, and in particular, for example, relating to the level of reliance on either technology or humans, and also focused on oversight and accountability. So the National Center for Technology and Dispute Resolution and the International Council for Online Dispute Resolution sought to develop a response to the disruptive nature of technology, particularly in dispute handling. And we wanted to pay attention to how technology was changing communication, dispute handling, and disputes development across different sectors of society and jurisdictions, the increased risks not just for disputants but also for third parties, and as I mentioned already, for trying to foster the use of AI for transforming, not just replicating, or making typical patterns of dispute resolution more efficient. And then we had to pay attention to the fact that clearly governance mechanisms are going to need to be repeatedly updated as technology changes quickly. So the goals were to respond to that disruptive nature, but also to make standards that would be thin enough that they could be used in conjunction with jurisdictionally present legislation and regulation, and also interpreted in ways that were relevant to sectors and to cultures in different parts of the world. So, I'm just going to mention the bodies that I've been working with, but clearly there's been incredible work around the world that we've partnered with other organizations, but I'll briefly talk about the center and iCoder here. So in the late 90s, the center brainstormed the idea of applying technology specifically, as I mentioned already, to negotiation, mediation, and ombudsing. And then about a decade later, issued a first set of ODR standards. Then in 2017, we developed a membership organization that we welcome everyone to join, and it was also created to be a standards-making body, and that iCoder updated the 2009 standards. And then in May 2022, the two organizations worked together to revise those standards in order to add AI. Here they are. Each one has one or two paragraphs that's entirely focused on the relationship between technology and disputing. And you can find that at odr.info or icoder.org. I'm just going to look at a couple of them before I start to move towards closure and talking about implementation of them. So you can see I've highlighted the components that are about AI. So under the standard of accountable, it says, this must include human oversight of the traceability of the originality of documents and the path to outcome when AI is employed, and the determination of the relative control given to human and AI decision-making strategies and outcomes. Equal. ODR system design must include proactive efforts to prevent any AI decision-making function from creating, replicating, or compounding bias in process or outcome. Human oversight is required in ODR system design and auditing to identify bias, make findings transparent to ODR providers and users, and eliminate bias in ODR processes and outcomes. Now here again, I would just say, we're talking about ODR meaning anyone who's providing dispute resolution or dispute handling services in court or outside of court using any form of technology. And in this component, focusing on AI. And lastly, highlighting under the standard transparent, the sources and methods used to gather any data that influences any decision made by AI must be disclosed to all parties. ODR that uses AI must publicly affirm compliance with jurisdictionally relevant legislation, regulations, or in their absence, guidelines on transparency and fairness of AI systems. ODR must clearly disclose the role and the magnitude of technology's influence on restricting or generating options and in the final decisions or outcomes. So since 2022, with these new AI infused guidelines, and since 2017 with the original ones, we've been encouraging practitioners, courts, ODR system providers to self-certify. To say this matters, we want to live up to this. And to encourage entities that certify or hold rosters or provide qualifications or credentialing to either require it or certainly to encourage it. And those that are hiring firms to create ODR systems to give this standards as a requirement for the development. I could not be more thrilled to say that 2 years ago in October in this room, when I was up presenting what we hoped would happen, this was the first time or first place in public that it was announced that there was a possibility that ISO was going to adopt these. And I'm thrilled to say that in March, the International Standards Organization did adopt the standards in full, verbatim. The only thing is they changed the required by law to not use the word must, so the word should is instead. Otherwise, the ODR standards that include AI are now required for transactional assurance regarding e-commerce guidance for those that offer any form of dispute resolution using technology. And there are 174 countries that have standards bodies that belong to ISO. So just take a moment because this book just came out. And it seemed like an audience that may be interested, that myself and 3 of my colleagues are very interested in the kind of high-level, 300,000 foot looking down at the history of how regulation gets developed and how legislation gets developed, the importance of international standards and profession-specific standards, and how we're arguing fundamentally that in order to govern AI, we need an entire ecosystem. All those components are necessary. And there's a chapter specifically on how we hope that the online dispute resolution standards are helping to reflect, as I said, the disruptive nature of technology. That if we stay in our sectors, if we stay in our disciplines, and we don't work from our own disciplinary perspective, as our leading keynote encouraged us, I hope I'm quoting her correctly, to stay with our frameworks, but also learn from each other and collaborate in order to create standards that are very important. And also, as I mentioned, the ODR standards are thin, which means that they're both hopefully relevant and also insufficient, because we need guidance and best practices for how to implement them. And I want to take the moment standing up here to say hats off to the Quebec Appeals Court for role modeling a way to concretize something that I see in the standards. And lastly, I'm just happy to be in touch with others who'd like to talk more about it. Thank you very much.
So, thank you. I would like to talk today about how CLEO is thinking about using AI to increase access to justice. CLEO's guided pathways, which is the means by which we're seeking to do this, are direct to public legal applications that help people understand their legal rights, complete court forms, draft other legal documents, and identify next steps like filing their forms with the court. The pathways are free to use and live on a public legal information website that serves Ontario, which is Canada's largest province. We have over 103 of these guided pathways in English, 73 in French. So each of these pathways is a use case or process, and these are grouped together into associated collections covering 7 areas of law. And we've been researching how AI can enhance these guided pathways, exploring how it can help deliver new help to self-represented litigants, and importantly, to the people who often help self-represented litigants who might not be able to use this technology themselves. Our research started with a problem, what I'll call our decision tree paradox, and that the very question and answer process that we use with this technology to reduce task complexity, that ensures users provide the information that they absolutely need to in order to make out their claim, can in fact detract from the narrative flow of their stories. And there's more about this and why it's important in a paper by Professors Amy Salazin and Jackie Burkell, linked here. So this paradox, decision tree paradox, is a problem we thought Gen AI could help us solve by improving the narratives collected by our guided pathway decision trees. And this idea is now the core of a 3-year research initiative to experiment, test, evaluate, and implement what works. And for more on this, you can read a discussion paper we published last year, and the link is here. Very quickly, this project's funded by the Law Foundation of Ontario, and we're working with McGill and the Montreal Cyberjustice Lab on evaluation, and Tango work on development in AI. So, on to a demonstration. So start the demonstration with the guided pathway decision tree that folks would see. I'll see a slightly longer version of this. And this is non-AI decision tree technology. And it's how we use, how we reduce the task complexity of filling out court forms. And this particular court form is for an emergency motion in a family law matter. It's high stakes. It's a remedy that litigants would seek without notice to the other party. Restraining order, exclusive possession of the home, custody of the kids. And what you see here is the decision tree technology, what we call our guided pathways, asking close-ended questions. And we have throughout embedded public legal information. Anyway, the idea of the technology is the way we use it, we ask close-ended questions, we present public legal information, we describe, say, this is abuse, we ask whether this is something that you can relate to. If the user selects yes, then we direct them to provide information on that piece. And the pathway in its entirety can take anywhere from 2 to 4 hours. And at the end, the user receives a court form that is used to start this process with their story on a Schedule A, where we've guided them through this expert system to provide their story thematically, and then we've used rules to organize it. And so in an effort to find, and I'm just using a shortcut here, so what we have done is we have used AI, in this case ChatGPT, and it's taking a moment because there's some privacy-enhancing technology that we've stuck in our tech stack between our system and OpenAI. And this is all on a research site. This is not available for the public yet. But we then use generative AI to take that information that's been collected thematically by the decision tree and reconstitute it as a narrative story that reads more compellingly. And we chose this pathway as a use case in part because folks that work with people that are fleeing intimate partner violence indicated that the guided pathways were very helpful in terms of delivering the court the information it needed in order to make a decision on the remedy, but that the persuasiveness of the story mattered a great deal in these hearings, and that AI. And so what we see here is the output that was built with rules being reconstituted using AI. And with some success in that process, we noticed that a lot of what the AI did well would fall under the category of a reasonable inference. And what a lawyer might do when given a client's story, let's present the facts in a way that more directly aligns with the legal test. But sometimes that reasonable inference would introduce inaccuracies that, if left uncorrected, could in fact impinge the credibility of the applicant. And so once the narrative is generated, there is a warning, you need to review it. And what we've done is we use another AI process to identify anywhere where we think a change has been made and highlighted it. And if you scroll over, you'll see a brief explanation that the AI has generated as to what the change is. And so you can say, okay, got it, or no, I want to edit that. And then the user can make whatever change is necessary. So one of the pieces that we weren't expecting to add to this process at the outset, but that we found to be very helpful, were suggestions. And so we have at the top here this button that the user can select to make suggestions. So here it says, paragraph 12, would it be possible to include an additional detail about how long the children were missing before they were found, and whether you contacted the police or any authorities during that time. And essentially what's happening in the back end is there's a 34-page single-lined job aid or expert checklist, and it is looking at all the reasons why the emergency motions fail, and then analyzing the content that's been provided by the user and generating suggestions referencing the paragraph numbers. So here, paragraph 11, would you clarify whether the former partner had permission to pick up children from the day of school when the partner did that, and whether this was the first time you took the children without your knowledge and consent. So this is all information that would conceivably be helpful to the user's, to the applicant's case. So how do we know it works? I'm not going to delve too far into our evaluation process. I will say that it's elaborate. It involves a 4-step process. Testing, we use synthetic data, testing LM configuration and prompts, testing the efficacy of promising, or assessing the efficacy of promising results, calibrating those assessments, and testing again. There's quite a bit more on the process, our process of evaluation, including our commitment to trial and error, benchmarking, inter-rater reliability, and calibrating human and AI forms of assessment on the web presentation that is linked here. What I would like to do is share very quickly what we've learned so far. So what's promising? Higher quality drafts. The technology is returning clearer, more persuasive narratives. These are narratives that are aligned to legal tests. The technology is doing a good job of filtering out extraneous versus required facts. Its outputs are encouragingly scenario tuned, so in emergency motions, it's good at emphasizing urgency and danger and providing concrete details, whereas on a small claims court hearing or small claims court claim, it's looking at contract, breach facts, more neutral in tone. The structure is much stronger, using topic sentences, point first syntax. There's no bearing of the lead. The reasoning context helps. We've provided legal reasoning in our prompts, and this has boosted performance. The suggestions feature I showed you it appears to target specific gaps that users can fill. And that highlight review feature that I briefly showed you is surfacing AI inferences, preserving user agency and reducing what might otherwise be unnoticed errors. So in terms of challenges, it's not 100% perfect, high quality overall, but some outputs still miss the mark. Of course, AI variability. There are incorrect inferences that are made from time to time that must be caught in review. And garbage in, garbage out. User errors in the decision tree inputs then get processed and incorporated into the outputs. Content management is also a challenge, and privacy implications are also a very difficult piece that we are working on as well. In terms of next steps, community engagement, we're committed to working with the communities we serve to develop these tools. Privacy enhancing technology, we're working now on solutions that de-identify and re-identify user data in real time so that we can leverage the most powerful external LLMs without exposing people's sensitive information. This is quite complex as it relates to unstructured data that you would see in a narrative. And file uploading. So as the privacy enhancing technology evolves, we're very interested in developing the ability to upload files and new information for analysis and using checklists. And so with that last point in mind, I wanted to delve just a little deeper into that make a suggestion feature, what we call our claim checker. As demoed, it generates real-time suggestions by analyzing, in this case, an affidavit built from the structured decision tree data. And then this draft is checked against a detailed job aid. In the case you saw, it's 34 pages long. And this pairing of structured facts and codified criteria helps the AI flag missing facts, legal elements, and display targeted suggestions to the user. The early results have been quite promising, and we think this same approach can extend to added inputs, so uploaded documents, updates from the user, while keeping the analysis anchored in the user's story and job aids that we provide the AI. In short, we think a system like this could operationalize expert checklists at scale to surface gaps and coach the user. The result, we think, is going to be a chat-styled coach. So unpacking this idea, we can see it starting by asking for additional information post-pathway. For instance, the suggestion feature could ask the user to upload a report or a document, other document that was referenced in their story. The user uploads the document, leading to further AI analysis that targets missing details, explanations, suggests next steps, ultimately strengthening their narrative. And it's this approach that we think can extend to other tasks, such as marshalling evidence, drafting speaking notes, questions for hearing, practicing with feedback, understanding the ramifications of the opposing party's submissions, correspondence from the adjudicator, all using this combination of RAG prompt suggestions, expert checklists, mini decision trees, and of course, the user's story. So this AI coach, we think, could help throughout the user's journey. So pre-pathway, routing them to the right tool, including by analyzing whatever letter or document they have. Post-pathway, asking for missing who, what, when, where, how, flagging inconsistencies, surfacing sensitive must-keep facts, again, asking for documents referenced, and presenting a chat-assisted drafting process that sort of suggests clarifications, places the edits in line. Pre-hearing, we sort of see this turning to expert checklists into a session-by-session micro-tasks, organizing evidence, analyzing correspondence, new material, drafting opening statements, witness questions, pushing mini pathways to collect more structured data, and of course during hearing, reminders, helping with structured note-taking, helping the user to interpret what happened that day at hearing. And we're already working toward this vision. So pre-pathway, we're near release an AI chatbot for tech support and common questions, which we hope will eventually expand so as to use AI to triage users to the right pathway or post-pathway. Post-guided pathway, we see this claim checker feature evolving into a pathway coach of sorts. Again, reviewing drafts, integrating new evidence, correspondence, guiding next steps. Together, an end-to-end assistive layer, AI at intake, AI after form generation to help users progress confidently toward their hearing and beyond. Okay, I lost track of time with all the. Okay, thank you. I look forward to answering any questions.
Okay, so thank you for the invitation. I'll try just to present a very small and very modest field work we've done. And so my point here is to try to emphasize the fact that we should avoid talking about AI as such, but just insist on AI systems and AI systems embedded within organizational design. So that's kind of terminology that I will get through during the presentation. Well, the problem is that at the really very start, I must say that I've got a problem, I'm facing a problem, because all what I did with my students is based on a study that was made on field before ChatGPT appeared. Well, there's no way. Maybe that doesn't make any sense. No, but it makes sense, since our colleague just was talking about decision trees, and decision trees have been existing for years, so it's still something valid and still operating, even though it's implemented and amplified by the LLM in some situation. So there was life before it, before ChatGPT, just remind us. And there is still many lives, in fact. Of course, this work is very limited compared to what Fabien Gélinas and Alexandra Pasca did, what you did, Fabien, which was a huge evaluation of all these systems before we did the job. So it's very limited, but we are focusing much more on the aspect of the organizational dimension of these systems. What is important to insist on is the fact that we are relying on the idea of a pluralism of AI systems and principles to be maintained and adapted to the real processes of the judicial actors. This work has been limited to decision support systems and not to conversational ones, as we see before. That's really something that is still really relevant and still very requiring a lot of investment. And of course, the kind of issues we are addressing are very, very different when you look for decision-making systems or conversational ones. I think sometimes we are completely confusing both, and I think there are many stakes that are very, very different, And we are dealing with jury metrics and not predictive justice, if needed to precise that. What I like to do is to develop the model that we created from the observation on how we can assess the appropriation of AI systems, and not the performance of the systems themselves, but the appropriation of AI systems at each step. So it's not just a performance or conformity with standards. That's a very important point. Our main field was made in a French private law firm, commercial litigations and intellectual property disputes. So the company was called Case Law Analytics, for some of you, maybe you're familiar with. And what is interesting is that we had to compare the goals and the specification of the AI system and its implementation, which makes a difference. Of course, all what is advertised is not really what you got on your desk, at the moment you work with it. It's quite simple to understand. And the comparison was also about the appropriation strategies by the professionals. It's mainly lawyers that was getting in touch with this kind of technology, but some other professionals as well. But it was specifically the most expert ones. That's a part of the result that are very significant for us. And of course, we had some extension to other firms just using the same systems. The important point in the work we've done is about the fact that the key factor must be considered as the coupling process between organization and AI systems. You will notice that I use only the term AI systems and never AI, never. It doesn't make any sense to use AI. It's AI systems, which means embedded within software, within applications. That's the only one we have access to. We don't get access to the model as such. Nobody does that, first. And second, we are not talking about the human in the loop, because of course we are aware of the remarks you made before, just in the presentation, but more not only put the machine in the loop, which I would agree with, but also the fact that it's a question of organization. It's a collective, it's a process, it's a really workflows and so on, and it's not just the individual that you put just in the middle of a technical milieu. That doesn't make sense at all. So that's why we are focusing on organizations, and I think it makes a difference in the way we are dealing with all the implementation, appropriation processes, and so on. And so it's not only an impact assessment, but the quality of integration and empowerment of actors. That's the way we translate the idea of autonomy. It means some kind of empowerment. In the end, who is learning? What we used to call, before we used to speak about machine learning, I used to emphasize the human machine learning. Now I don't know how we call that, but anyway, it's not a division of learning, which is what Shoshana Zuboff warns us about. The fact that if you let the companies that are providing the AI systems to learn from all the data that you provide them with and the expertise that you have, in the end, there will be a division of learning with these companies learning everything and extracting all your own expertise, and you will be the one with nothing left, because you, of course, you will not be improving your expertise and improving your the way you work. And this is a real issue, a real sociological and political issue that we must be aware of. So we built some kind of some grids of indicator, quantitative data about the performance of the system. Still, of course, there's objective part of the assessment in some way, but the qualitative data also about the quality assessment to be made by the stakeholders themselves, which means that we are not just experts coming from outside and just telling that's the real benchmark from which you will be compared. All the people have their own capacity to analyze that and to have an assessment that is relevant for their own environment, in their own cultural and organizational situation. So the level of involvement of actors as well is also a key point. Well, there were different phases, of course. We do go all through the process: initiation phase, development phase, organizational design, the commercial use. And of course, it's a very different philosophy compared to the kind of disruptive acting out of AI firms. They just come out of the blue and saying, wow, we got the solution for everything. No, we need to have step by step the description and specification made with the people that are really concerned by the system itself. So we developed something which looks very traditional, very old-fashioned, but I don't care. That's exactly what we used to do, even though when we're working with symbolic AI, and it's still relevant, because what I would like you to be aware of is the number of features that are not considered as valid, as of some interest, when we adopt AI systems, the generative ones. We don't care. No description, no specification at all. Just a basic legal, general purpose and interest, and that's it. Here we need to have all these descriptions, very precise one, and we get deep into that for each of them. I just give you some example. For instance, here, the initiation phase, you have to discuss the targets, the stakeholders. So we have indicators, sub-indicators, possible values. It looks like it's an ontology. Yes, it looks, yeah, that's not a bad word, You can use it still. But it means that you need have a requirement of precise description of all the features in order to be able to explicit them and to make a real deliberation among the stakeholders that are involved in this project, So you can map the target, internal one, but also the external one, because the stakeholders are not only your practitioners or the administrative staff, it can be also the clients and many other profiles that can be interested in how you develop your systems in this situation. Maybe I didn't mention that. Yes, for the commercial litigation about property, intellectual property, for instance, well, that's something, there are many other people interested in that for various reasons, And of course, you may get deeper and deeper into the socio-demographics and the socio-organization of the targets, You do the same with the creation of the learning database. That's a more technical part, but there is a lot of description and features that we've been listing coming out of the description of the precise observation. And we had the sources, the heterogeneity, their interoperability, the conversion, extension, alignment with strategic objective, and so on, sufficient volume, sufficient updating, and so on. All elements that the companies that will offer services, of course, consider in the back office in some way, but sometimes they must get make it explicit so that we have a real discussion with the stakeholders. It's not just a question of back office and specification of the technical capabilities. Everything must be put on the table so that the autonomy of the judicial actors is really announced. The same for user experience. Formal user test and so on, something we don't know almost anymore. Testing is something that is supposed to be in the old times for specific industrial sectors and nothing related to what AI systems do. We still need these formal testing processes, and I think that's really important to keep it in the time and the process of developing. And then organizational design, which is my key point here, is the fact that we need to describe and to understand how the collective itself get organized with some tacit rules, some traditions, some very low efficiency systems, okay, but how, what is their signification? Why is it still operated that way? There are always many good reasons for that. So we need to get into that before we think we can wipe out everything so that we disrupt all this organization and make all the people despaired and leaving sometimes and saying, well, we are not completely unable to adapt to the technology. No, that's not true. The technology, but it should be put the other way, the technology must be completely adapted to these features as well. Of course, it goes back both ways, of course, at some moment. So in organizational strategy, the general policy, the strategy, the marketing, the internal image, and so on, all these are features, important ones. So I will skip the main lessons, the fact that, in fact, in the end, the demand from the client was a quantified litigation risk to assess it previously, so that's really important for them. And it worked. From this point of view, it worked. But what is important is that the selection of the criteria for the development was based on the human feedback, which was not just a feedback later on, but at the right moment of the decision for the development itself. And one feature one observation that is really significant as well is that, in fact, this tool worked pretty well at the beginning, just for less than 1 year, and then it lost momentum due to the lack of training and the updating. There was not a real ongoing process, and the workflow itself was not so well integrated. So that's exactly how technology that might seem very interesting and profitable at the beginning get lost into the routine or into the fact that it should make miracles, but it never did that. That doesn't work that way. You have to maintain them, to improve them, to redesign them, to reinvent them very often, as long as you go on in the use process. So what are the conditions of felicity, I would say, for the successful transformation? Of course, it's part of a broader organization transformation, which is much more time-consuming than technical development. I'm sorry for all the engineers that are really considering that their work is really heavy work, and so, but the organizational work is much heavier and much more complicated because we have to describe everything, every feature, and to make sure everybody gets involved into this kind of process. The problem is that when we adopt that with the LLM services, the AI company do not give you any insight about that. They don't care. Even when you speak about the shadow AI, we are familiar with that. Everybody is using a part of the system. We don't know which one is it, and boop, you get to make things work all by yourself on your desk, and that's it. And the success, of course, will not depend on technical quality alone, but also in the integration into workflow, data ecosystems, professional culture, and it's always specific. That is a real problem with LLM, because the philosophy of the LLM is to pretend to be universal. Whenever you try to adapt with RAG, with retrieval augmented generation, of course, there are always ways to say, no, we'll get more closer to the real specific environment and culture that you are experiencing. In the end, the principle of the technology is to get rid of all these differences and to obtain some kind of average solutions, which is a real problem, cultural and political and organizational, of course. And the trust in tools require transparency and design choices and quality of data. And the problem with the LLM, if you want to discuss, you need to explicit a larger part, as much as you can, of the data that you are using. But in fact, we are moving into more and more opacity and inexplicability, which is not really what even the computer scientists were looking for from 10 years from now. You know, they were really asking for that and still working for that as well. And the problem is that evaluation is, that's why we developed this kind of grid, just to help people be sure that they check all the features that are still required to understand how far they really have some benefit to adopt this kind of technology, because if not, you are just watching the benchmarks that are available everywhere between various kind of LLMs, and you say, well, it's just a formal performance that make no sense for a specific use within a specific organization. And so how can you avoid, and I will stop just in a minute, how to avoid the disembedding of calculation, because this is the cultural phenomenon that we're observing right now, you know, the calculation, and we had a wonderful workshop with Jean Lassègue yesterday about that, you know, the fact that the calculation is becoming overwhelming all the aspects of social life and completely getting disembedded from the organization and the culture and the references that they should be start from, you know. And so that's really a risk that we have. Of course, we observe that the LLM systems are LLM-based AI are trying to reintroduce some semantics through annotation, moderation, retrieve, RAG, as I mentioned, chain of thought, RLHF, and so on. But in fact, it's just a way to mitigate the crucial weaknesses of LLM. You know, it's just a way to repel the real truth of the fact that they are not in position to deliver a really comprehensive understanding of any situation. They are just providing you with statistic data that are really of limited value in many specifically decision-making systems, you know. So, my concluding remarks will be that we need to involve the understanding of organizational design, the role reallocation, cultural adaptation, and of course, the evaluation itself must be participatory and context sensitive. And the successful adoption will depend on aligning, we speak a lot of alignment, you know, but aligning technical solutions with organizational realities and stakeholder expectations. And of course, this is what we tried to do, but as I mentioned before, maybe that has to be completely reinvented and readapted to the environment of LLMs, because the pressure is so strong that maybe all this long-term development and specification of the organizational conditions for that are really considered as no valid at all, you know. Thank you.
So, why am I talking about this? Well, the education of law is, of course, one of the kind of formation points of many actors in the judicial system. So getting this right, especially in this new time, I think is important for the overall system. So I'll briefly introduce this topic, then make a quick demonstration, show why this is interesting, talk about some analogies that can be used to understand the role of generative AI in teaching. Talk about the approach we took in Maastricht, so this is based on some guidelines that were released in last month, and then briefly look towards the future to see if there are some interest, some overall lines drawn from this. So, well, as we know, there's been the emergence recently of large language models. That is, models that are able to do many different tasks in writing based on completing the next word. An issue is that LLMs can or seem to be able to help with or automate many skills taught to law students and students in general. Now, the AI companies are aware of this. There's been many investigations of, by Anthropic, for example, how university students use Claude. And they are starting to systematize this, so looking at people using this for problem solving or output creation, either directly or collaboratively together with an AI. and also looking at the different tasks that AI is used for in the Bloom's taxonomy. That is creation, evaluation, analyzing, and so on. As you can see here, students do use it quite at a high level here for creating and analyzing context, which is kind of some of the core of understanding and learning. So, how do we teach law then in the era of generative AI? What changes and how shall we do this to ensure that we shape lawyers that are well adapted to this future while retaining the key skills? Now, one of the interesting kind of nuances here is the idea of the law and some other fields compared to some other fields. In law, of course, like some other fields as well, writing is the core tool. Like writing, analyzing, drafting legal arguments is really at the core of what we do, while in STEM fields, for example, writing is kind of a summary of what has been done in experiments, for example. So in that way, there is the potential in law for LLMs to go very far. They can really take this core of legal thinking and reasoning and do that, which means that it could go further than maybe in some other fields. So just to quickly, I know you're all aware of this, but to quickly show you how what these models can do today. This is deep research. This is deep research. This is a feature of OpenAI where you can ask a question, and instead of directly answering here, it will spend a lot of time thinking about an answer and then return this answer. So here I asked it write a thesis to answer the research question, how does the legal framework regulating generative AI differ between Europe and Canada? It then asked me to clarify a few points here. We're focusing on current laws. We're also proposed for upcoming legislation like the AI Act. Maybe not quite correct there. Should the thesis include ethical implications, enforcement mechanisms, and so on? I was quite lazy here, so I said yes to all of the above. Focus on master level thesis. And what happens then is that the AI will start thinking. And in this case, it did think, I can't see it here, but it did think for around 20 minutes. And you can follow what it does. It will tell you what it's currently doing, what it's looking at, which sources it's looking at, and so on. And it will then give you a text. So the text you see here was written, in about 20 minutes. And we can see that it follows, it has an abstract here. It's called Comparative Legal Frameworks for Regulating Generative AI in Europe and Canada. And it is quite a substantial text. It has an introduction here. It looks at Europe's regulatory framework. It goes quite in depth here. At some point it starts looking at the Canadian framework with the AIDA, and then it starts comparing the two. If I go further down here, risk-based versus sectoral, prescriptive versus principle-based, and kind of explains all this. And what's different here is that it will use sources. In this case, it used 14 sources, but there's systems that can use many hundred to incorporate that. And you can see that this is not bad. I'm not going to say it's a great thesis, but if you received this as a thesis and didn't know it was written by AI, I wouldn't be surprised if this would at least pass. And again, this is early stage, right? It's very possible that in the next few years there'll be systems that can write theses that are even better than that and excellent. So you can see we're moving very quickly into an area where legal writing, at least at the student level, at the bachelor or master level, could be significantly affected by these models potentially. Good. So what does this imply for law students? Well, first of all, the one issue may be that students don't learn like they used to. If people use generative AI for these tasks instead of going into them themselves and thinking about the problems, going in depth, wrangling with the issues, drafting text, correcting the text, getting feedback, and so on, they might skip over the crucial practice that kind of trains their muscle required to become good lawyers. There is another thing that I'll get back to as well. One of the purposes of the university degree is, of course, showing to employers that students are good at law, that they can do legal reasoning and legal writing. Of course, if suddenly everyone can use generative AI to pass this test, to write a thesis, maybe this will be less relevant. And then there's a point that cheating is democratized. This, I think, is also important to keep in perspective, is that people have cheated in law school for a long time. People ask other people to write theses for them or even pay them. The difference now is that everyone can do this. So it's an interesting nuance there, is that people may have already been doing this way before ChatGPT, but now could become much more prevalent. So there's starting to be some very interesting studies that look at the effects of using generative AI for tasks and how it affects work and learning and so on. So this study here out of MIT is called Your Brain on ChatGPT, Accumulation of Cognitive Debt When Using an AI Assistant for Essay Writing Task. So essentially used 3 cohorts of students, some that used LLMs very extensively and some less so and some not at all, and then physically looked at the brain and how the networks developed in there, and saw there was a physical difference between people who used ChatGPT for writing and those who didn't. And the results was that it was better, the circuit, or the people learned better without using that, which they could see in the brain. Of course, these are quite small-scale studies. You would, of course, much more research to do there, but definitely some interesting early results. So how shall we think about generative AI for students then? And I think it's interesting to think about some analogies, as they can frame your thinking, but also maybe in ways that aren't ideal. So one analogy that often comes up is that of the calculator. That is, we have this technological tool, and people can use it, but it will turn out that the real high-level way of thinking is not, in fact, the calculation itself. That is how to use the calculator, how to enter the numbers, how to input the different operations, and so on. This is something we went through in math. I've heard people say that there was a similar discussion then. Can we really give math student calculators? But of course, today this is very accepted, even though people still learn to calculate in their head as well. So that's one analogy. But we also saw how far these models can go in a way that maybe calculators couldn't. Calculators are very reliant on the instructions here, but we saw that based on just a research question, these models can generate something that looked like a very complete thesis. So maybe it's more like thinking about a research assistant. That is an entity that you can speak to, a person that will do something for you that you can then look at, provide feedback, and maybe correct some yourself, but it's something that can save you a lot of time and be incredibly helpful in these as an academic. Now, this is also a way of looking at it, but coming from a student perspective, of course, bachelor students aren't allowed to hire research assistants to do tasks for them, but I think that is an interesting way of looking at it. Finally, we have the idea of the forklift in a gym, which I've also seen come up, which is the idea that AI is like, taking a forklift to a gym to lift the weights. You can do that and you will lift weights very successfully, but you kind of miss the point, because the idea of going to the gym is, of course, to get stronger and become more musculous. So that is also a way of looking at AI in teaching. Of course, analogies are limited. It's important to think about AI is something new. I don't think you can really transfer all these ideas from these fields to this thing. And in fact, you've got to be a bit careful with that, I think, since there are very attributes here that are, I think quite unique and deserve reflection on their own in their own world. Good. So we thought about this in Maastricht, and in the end we came up with a framework or guidelines that were adopted last month. In general, there was a university-level policy framework that was adopted, and the idea here was that we should be an early majority, not to be the first people, but to be part of the early big group that starts using these tools. So a quite positive look at these tools. We also made, so this is the document I worked on, Gen AI Guidelines for Legal Academic Writing. So these are guidelines specifically for the law faculty. And here we kind of split it into two fields, first education and then examination. And in education, we argue that generative AI will likely be part of the legal profession of the future. It is likely, we don't know where the development will go, but it is likely people will rely on them to some extent. So to effectively do that, we say in this document, students do need to learn, first of all, how to write without LLMs. This is, of course, a way to get the skills in the first place, to practice that skill, to train that muscle of doing legal writing and reasoning. But also, in my opinion, it is crucial to know how to write without LLMs to effectively write with LLMs. Understanding how legal reasoning works, understanding drafting, understanding critical thinking is really important to look at the outputs of these models and to decide if it's something that should be adapted or changed or is not useful at all. But also, we plan to integrate the idea of how to effectively use large language models in the course as well. And the idea is that these models will likely be part of the legal profession, and we should equip students to be able to benefit from them and use them in a way that is, again, critical and safe and responsible, but also that allows them to benefit from these tools. Of course, through all this, it's important to ensure responsible use, transparency, and fairness between students as well, since students might have access to different models with different advantages, which could introduce inequity in the teaching as well. Comes to examination. So for education, we said this is up to course coordinators. They should decide, or program directors, where AI use makes sense, how to integrate it properly, and to ensure a mix of courses that use and do not use large language models. Now for thesis, we decided these also function as proof of competency. They're a signal to the employer. The output here is important in itself to show students are able to write to this level. And possess the skills of legal reasoning, research, and writing, and so on. So here we introduced kind of faculty level guidelines that says what people are allowed to use this for in the thesis writing. Again, of course, we ensured people are responsible, it must be used responsibly, and people also must put intermediate versions so that we can see how they used it. But in general, we kind of split it into categories, some of whom are allowed, like the ones you see here, searching for literature, translation of third-party texts, explaining the meaning of words, and so on. Now, yellow things, summarizing, explaining laws, case laws, or document, brainstorming, peer review, and improving an already detailed structure. And then we have things that are fully not permitted, such as defining a research question, or basically text that ends up in the thesis in the end. And for the ones that were borderline, we also put example prompts that people can use to ensure that they don't go over that line. Now, I'm not sure if this is the perfect balance. I think it can be a lot argued there. I don't think anyone really knows at this stage, but I do think it's important to have clarity at this point, and the idea is that we'll come back to these and adapt them as practice changes. So let's briefly look to the future, and kind of coming back to what I said before. I think there's today different reasons why people go to university. One is to learn, to improve your skills, but there's also to eventually get a job, to get a degree that will allow you to work in a field. So I came across, and the second one is, it's interesting that with generative AI, there is incentives to kind of prioritize the second one over the first, to kind of use this for drafting to get that degree, even if maybe you aren't able to spend the time. Which maybe impinges on the learning then. This is also not a new thing, right? People are always, students sometimes ask, will this be on the exam? Classic question, which maybe shows that people already care more about the examination than learning itself. So very briefly, an interesting editorial I came across in Sweden was that some academics said that we should get rid of examinations, to focus on lifelong learning instead and leave the industry to assess the competency, which might also leave professors more time for teaching. I'm not sure if that is the way to go, but certainly an interesting view. So just to kind of raise some long-term questions here that I think are interesting. I don't know the answers to these, but I think they are interesting. Is there inherent value in humans carrying out the task? I think that's an interesting element here of in-depth interactions with problems, allowing the better understanding and shaping of those problems. There is the idea of technology changing more quickly than culture. Students are already, to a large extent, using them very proficiently, these models. So it's already affecting the teaching environment, of course. And then there's implications of autonomy that I think we'll maybe have the chance to discuss in the panel. Thank you.